Okay, well, hello and welcome to this IconS New Scholarship Showcase event. This is a series featuring new books in public law, organized by the IconS Committee on New Directions in Scholarship. My name is Rehan Aberatna. I'm one of the co-chairs of this committee. My day job is as an associate professor at the Chinese University of Hong Kong, associate professor of law, I should say, at the Chinese University of Hong Kong. We have a terrific book and panel featured today. The book is Rebel Courts, The Administration of Justice by Armed Insurgents, published by Oxford University Press in 2021. The book won the IconS Book Prize this year, and we are very excited to feature it in this series. The author is Renee Provost, professor of law at the McGill University Faculty of Law. Congratulations again to you, Renee, for writing this great book and for receiving the prize. We have two excellent discussants with us today, both of whom served as judges on the IconS Book Prize Committee that selected Renee's book for this award. The first is Anne van Aken, who is the Alexander von Humboldt Professor, Chair for Law and Economics, Legal Theory, Public International Law, and European Law at the University of Hamburg. And the other is Giulio Napolitano, who is Professor of Public Law at the University of Roma Tre, Department of Law. So welcome to all three of you, and thank you very much for doing this. Let me just say a quick word about the format for today. So I will shortly invite Renee to introduce the book, which will be followed by comments from our two discussants, and then a response from the author. We will then hopefully have some time for a question and answer session. At that time, members of the audience, you are welcome to either send in questions via the chat function or to virtually raise your hand, and I will invite you to ask a question of the speakers. As I mentioned a minute ago, the session is recorded, and it will be later uploaded on the IconS YouTube channel. So with that said, why don't we get started? Renee, could I invite you to please introduce the book and maybe tell us a little bit about what led you to write it?
All right, thank you very much, Rehan, and thank you for the invitation to speak about my book. And I'll thank in advance Giulio and Anne for participating in this event. I was truly honored to receive the IconS prize. To have the chance to speak to this issue, which is one that I think has been largely under the radar for international lawyers, not something that has been discussed very much, and across which I came some years ago, more or less by accident. And as someone who's kind of interested in legal pluralism and the varieties of ways one can think about law, this struck me as an extreme challenge to the association of law and the state. And for several years, this remained at that level for me, until I realized that, in fact, this was a phenomenon which, beyond raising important and difficult issues around the idea of law, was also an extremely challenging reality for the protection of victims of war. And this spoke to the human rights lawyer in me, as well as the legal pluralist, because when we hear about those issues, it tends to be around highly politicized cases. And for example, recently, the courts in the People's Republic of Donetsk in eastern Ukraine convicted two British nationals and one Moroccan who had been serving in the armed forces of Ukraine. And this was, it made worldwide news. They were convicted to be executed for participating in the conflict and other crimes against the laws of this unrecognized entity. And these are the cases that tends to make it onto the media horizon and which have attracted to some extent the limited attention of lawyers. The reality is that the administration of justice by armed insurgents is a much broader phenomenon and a lot more ordinary. The starting point is that even in war, life goes on, and people need legal security for just everyday issues like divorce, custody disputes, broken contracts, land disputes, civil liability, the neighbor's cows escaped and trampled the field, and who's going to pay. And all of this keeps going on, even in the midst of armed conflict. So people need a resolution to those issues, and they will seek it wherever it is on offer. And in a footnote on the book, I speak about the Wi-Fi theory of the administration of justice or the rule of law to suggest that most people don't care who's giving them their Wi-Fi, if they're at a cafe or in the shopping mall. They don't care who the service provider is, as long as they get access to whatever they're looking for. And I think that the same is true for justice. For most people, they don't care who is actually behind the administration of justice, who the institutions offering justice stand for, as much as whether it is available, predictable, and fair. And this, of course, is a way of thinking about justice that is very much not what lawyers are trained to think about, because we are all raised in the law, so to speak, to approach it in a manner that is directly connected to the legitimacy of public authority reflecting state sovereignty. So this is the administration of justice by armed group is a part of a broader set of issues that has been labeled rebel governance, which is an emerging interdisciplinary field, or an emerging field, which looks at various practices by armed groups, including also, taxation is another important one, education, health, and so on and so forth. So the reality is that in many situations of armed conflicts, armed groups that exert authority over a territory and population will create some practice or some institution to administer justice. This is not systematically so, but very often it will be so. This is a reality that is largely unrecorded or suppressed by government. It is unexamined or reduced to a power grab by at the hands of rebels, and it is globally untheorized and delegitimized by governments who always characterize this as simply more criminal acts by armed rebels. So my starting point is the need for ordinary people to have justice, and whether international law offers tools and avenues to better understand the nature of such a process. And I think that various parts of international law do, in fact, offer elements that are building blocks for a different understanding of this practice of the administration of justice by armed groups, particularly international humanitarian law applicable to situations of armed conflicts, human rights law, international criminal law, and public international law generally. As an even broader framing device, I think legal pluralism is a more or less necessary stance to go very deeply into this issue. If your definition of law is limited to legal standards that are related to the state or that are validated by the state in some fashion, and that are administered by institutions that are either created by the state or at least authorized or tolerated by the state, of course, we don't go very far with the administration of justice by armed groups, because that is not the case. So you need a broader definition of law that detaches the concept from state legitimation. and thus it is for this book, which takes an approach that is grounded in a ambitious version of legal pluralism, sometimes described as radical legal pluralism, which sees law in many roots, as one person famously said. Another aspect of this is that is to go back to this this acknowledgement that very little is known about this practice. It tends to make the news only in a small number of cases that tend to all look the same, very politicized cases, but the sort of the bland, ordinary administration of justice by our group has attracted very, very little attention by scholars in any discipline. And I came to realize that as jurists, we really didn't know what we were talking about when we talk about rebel justice, because justice is so wrapped up in the small details of how justice is organized. It's not just a grand proposition of rebel law, but the very small details as to, how do you present a claim? Do you have access to evidence? How are judges appointed? Are there written decisions? What are procedural rules that govern the adduction of evidence, and so on and so forth? And so I came to conclude that it was necessary to have a series of case studies on rebel justice by our groups that try to get at this fine-grained description of how different armed groups in situations of armed conflict administered justice. And I carried out a preliminary study of 15 armed groups and brought it down to a smaller number of groups for which I did more in-depth studies, including field work in various parts of the world on the FARC in Colombia, the Islamic State in Iraq and Syria, the Taliban in Afghanistan, the Tamil Tigers in Sri Lanka, and the three main Kurdish groups in northern Iraq, northeastern Syria, and Turkey. And the idea was to both present these findings so that more information becomes available to everybody, but also to ground the legal analysis in the specifics of these case studies. And I've tried to connect the legal analysis to specific elements and examples from the case studies, although often I was frustrated in my attempts because it's so difficult to find this information that there are many, many, many gaps in my descriptions. And I did this to answer four main questions, and I'll close with just listing them. So the first is whether the idea of rebel justice is compatible with a reasonable understanding of the rule of law, as sort of a foundational question. Second, whether armed groups have a right under one of those fields of public international law that I listed to administer justice, or even perhaps a duty to do so. And I explained in the book that to some extent there is an argument to make that there is a duty. Third, if a rebel group creates a court, what are the requirements of due process to ensure a fair trial? So this is really, it gets to a much more minute and detailed understanding of legal standards and how they were applied by armed groups, which is where the real test of the fairness of the whole thing gets tested, gets ascertained. And finally, fourth, do other actors like international courts, like the ICC, the International Criminal Court, third states, the state against which the armed group is fighting, and other armed groups. Do all these entities, actors, have any obligation to give legal effects to decisions of rebel courts, what I describe as the rayonnement of rebel justice? So those are the 4 questions, and maybe I'll just stop here for now.
Okay, thank you very much for that, René. Could I invite Anne first to give us her comments? Thank you.
Yeah, thanks a lot. Great pleasure. And again, also my congratulations to René. It was really a pleasure to read that book. It's an extraordinary book. It's mind-boggling in its depth. The diversity of legal and legal theoretical arguments. And last, but certainly not least, the incredible effort undertaken by you, René, to study in the field under difficult circumstances, as you described. It's clearly an opus magnum, drawing on legal theory, international law, specifically IHL, human rights law and international criminal law, but also social science literature, and of course the method of investigation for the case studies was social science methodology. And I think what the book and why we could so easily agree is that this book really opens up our mind to things we rarely see. It also opens up understandings of phenomena of rebel administration of justice, which we tend to dismiss summarily as not being legitimate or just, but mostly we don't even see it. So I think that already is a great accomplishment, making us see it. Furthermore, it makes us rethink fundamental notions deeply ingrained and mostly unquestioned in our understanding of modern statehood, as well as international law. Namely, the coupling of administration of justice with the nation state, the exclusive monopoly of the state to the administration of justice, and the idea of what a court is, and how we apply, of course, and that's from the public international law point of view, how we apply the Geneva Conventions. And as you say, law and courts are legal concepts, they're labels, but they're not really ontological. So, and I think this is really the merit of the book, that you go far deeper than just of those labels, which we operate all the time, which we teach our students without really questioning them. So you make us question deep-seated notions of positivism and the necessary connection between the state, order, and justice. You question the traditional answer of the concept of law and the Hartgen concept of law, leading us to a pluralistic understanding of law and a non-state-centered normativity. You use the thin concept of the rule of law, you shed new light on how to understand courts, and you clearly question the sufficiency of international law, especially IHL and the Geneva Conventions, to deal with the phenomenon of rebel courts. I want to give just one example on how the deep digging reveals more about the labels as we usually use them. So you say that regular constitution of a court can be achieved by non-state armed groups by means other than legislation, inasmuch as it corresponds to a deliberate decision by and effective authority to establish a general process to apply identified law broadly defined. And by using those elements, you're able to label rebel courts as courts, actually. When you talk about the independence and the impartiality, you argue that those notions must be adapted to non-state actors reflecting their capacity and realities. And you always go back to the rationales of the label, and that makes, I think, the book so intriguing. Now, I have several questions prepared. Some of them you have already somehow answered in your introduction, but one question I wanted to pose is really what drove you to write this book. And in a way, you say so in the book sometimes, and you also said it now, and that there's a need for ordinary people of having fulfilled their justice needs. But I was still wondering whether there are two goals. So on the one hand, maybe the desire to rein in rebel courts under the umbrella of law, trying to make them better. So you say, so for example, ultimately the aim is to incentivize non-state governance practices that bring rebel justice closer to the ideals in human rights law. That's a quote from page 217. Or did you want to reveal the interests of behind those labels? So mainly the interests of states behind the non-acknowledgement of rebel justice, namely the safeguarding of sovereignty on the one hand, and the avoidance to the revelation of the insufficiency of state governance and justice in weak governance zones, or maybe not even only weak governance zones, right? So even in states where state justice, it's never ideal, but where state justice is insufficient. And in that connection, I wanted to ask you or draw your attention to the Hague Institute for the Internationalization of Law, which is now called the Hague Institute for Innovation of Law, because we basically have already internationalized our law. And they did, I used to work with them on their programmatic steering board so longer ago, but they started to do, they must have an incredible collection of data now on justice needs. So they do justice scans in countries like Mali, Yemen, Lebanon, and wherever they have access, and they usually get access, even in high conflict zones. And they really go from door to door, from hut to hut, and they ask people what they need. And I think that would be a really, I think your book would be fantastic for them, and their data would be fantastic for you in case you want to continue on this path, because it's a whole different way of looking at justice systems really from the bottom up, and this is what you're ultimately doing. And the second question concerns the structure, and you already alluded to it a little bit, that it was difficult on how to do that. But what you basically do is you take one question like the rule of law, and then you present the FARC as a case study. And for ISIS and Taliban, you talk about, that's basically about the legality of rebel courts, the Tamil Tigers on due process, and the Kurdish courts on recognition. And I was wondering about this because although it makes it very readable, because you go from this more narrative style of how those courts work, which is somehow more relaxing, to the much more complex legal theory parts, which is a nice, okay, use your brain and relax, use your brain and relax. So it goes a little bit in this, which makes it very nice to read. But I was wondering whether that also misses out to see those cases more holistically. So the FARC more holistically, or the ISIS or the Taliban justice more holistically. So can we talk about the rule of law in ISIS courts, yes or not? So things like that. And then I also would like to ask you, I mean, you clearly position yourself with the theory of legal pluralism, and that totally makes sense. Do you just take the legal pluralism theory as a background theory, or do you think that the book will also contribute to the theory of legal pluralism? That's one question. And if so, how and what would be the contribution to the theory? And last but not least, and you also said it now, because I think we're all preoccupied with the Donbas courts. How would you, let's say, if you would be asked by a judge in Canada or in Germany or in Poland how to qualify those courts and those judgments, and on giving them recognition, what would your answer be and why? That's it from my side for the moment.
Great, thank you very much. Could I now invite Giulio to give your comments, please?
Thank you very much. I also want to congratulate with Renee for this amazing book. I'm not leaking the works of our jury, but I have to confess and reveal that we were all fascinated by your book. So when we finally came to discuss your work, we immediately found an agreement among us. And I have to say that this was not easy at all, as we received 40 books, most of them of very high quality. And so at the beginning was not an easy choice, but in the end, we were all deeply pursued of the fact that your book was an excellent book and the right book for the purposes of the Icons Book Prize, because we read many interesting books that provide a very in-depth analysis of very relevant topics, as for instance, fundamental rights, rule-making by the executive power, and I could make several examples about this. But your book was very relevant for the IconS purposes, because, as Anne said, and you clearly said in your introduction, you really explored a new field with a very original approach and method, combining legal, social, economic perspectives, overcoming the divide between public law and private law, and between the national level and the supranational and the international one. So this was exactly what the society and what the jury was looking for. And I have to say that I also share your courage and your vision in legal pluralism, because you, to some extent, overcome the traditional approach, the legalistic approach in defining courts and law as typically state-based institutions. So I do think that courts exist beyond and even against the state. Beyond the state, it was somehow a well-received achievement once that the legal scholarships started to study the role of international courts or arbitration at the international level and so on. But entering into the frontier of justice against an established state, against an established government, is of course even more, and it challenges also our common sense of, and in some cases also our common beliefs, because in many cases rebel courts really threaten or violate human rights. They often operate in the middle of a civil war, and so citizens and foreigners can fall under the unfair judgments and the execution of those judgments in those contexts. However, I do think that you are right in your approach, and let me confess what is one of my favorite statements of your book, which is that is at page 414. In conclusion, the administration of justice by non-state armed groups in zones of armed conflicts is a legal fact that produces repercussions on the international legal plane that must be carefully examined, and if they meet the required elements of legality, acknowledged. And even more important is the immediately following statement: failure to do so, far from strengthening the international legal order, risks triggering dissonances within that regime and ultimately weaken humanitarian protection for the victims of war. And this is, let me say, a very important statement in terms of policy that I fully share. Of course, this opens a kind of tragic choice for international organizations or for other states, and even for the hostile and contested state. To what extent acknowledge this alternative justice? Because of course I see the dilemma: if you acknowledge this justice, you also run the risk of acknowledging the rebels as such, and to some extent you run the risk of undermining the legal stability and the legal identity of the contested state, as well as of the international legal order, as far as the contested state is at least formally part of that international legal order. But if you simply reject even the idea of this alternative justice, as you rightly argue, you have no chance of ensuring the respect of a minimal standard, of a minimal requirement of due process, human rights, and even, as you were very rightly saying also in your introduction today, the everyday functioning of the society, of the economy, and in the very end, the affected people, the damages will touch anyone, the common citizen, and this is a very relevant issue for the entire community, I think. So the point is how to balance, how to find the right way between these conflicting interests and perspectives. So I was wondering, and I want to hear, I'm curious to hear your opinion, is it possible to some extent a kind of third-party intervention, a kind of third-party assessment, a kind of third-party initiative in this regard? I mean, if it is possible for a judicial body of an international organization, or a special committee of the United Nations to some extent open a dialogue with rebel courts in order to ensure minimal requirements of the process, for instance, without compromising in that the overall international legal order or the contested state. Perhaps there are even specific institutions for the promotion of justice or for the nation building process in law and justice that could play this role as a kind of the blue caps of the United Nations in the army, a kind of blue caps of the United Nations in the field of justice, if this would be possible. One final word from a European perspective. Of course, your work is very challenging and stimulating, also in a different perspective. Your attempt to identify the core concept and the basic requirements of due process and rule of law to assess the let's say external lawfulness of rebel courts can become even a powerful term of reference for the debate, for the very controversial debate we have in the European Union about due process and rule of law by member states of the Union. Everybody knows that there is an open procedure on that about the respect of rule of law and justice by some member states of the European Union. Of course, the definition of these standards can become a very demanding and controversial issue, not only for rebel courts, but also for governmental courts. Thank you so much.
Great, thank you, Giulio. Actually, thank you both. Such rich comments and so many questions for you, Renee. So let me hand it back to you for your response.
Okay, thank you indeed to Anne and Giulio. So let me touch upon some of those issues in turn. I'm not sure I can really answer everything that was raised, but let me raise a few issues. Maybe Anne, you started by speaking to the methodology of the book, and I think I'm not sure whether this is a reality that is prevalent or emerging already in your respective universities, but I think there is an emerging trend of doctoral students to include some kind of empirical dimension to their doctoral projects. I think this is happening in many places, and it poses a challenge for us as established academics, because that is not the way most of us were trained, and we are ill placed to guide our students in a kind of academic investigation that we ourselves have never done, and for which there is no ready set methodology. Law is a very poor academic field when it comes to methodology, and what we call methodology is, I read cases and articles and I write about them, and this is, I think, my book kind of highlights, I think, a transformation of law as a discipline, perhaps to signal the need for taking methodology more seriously, and to become a little bit more rigorous as a university discipline, and to learn from social sciences. A lot of my my approach to field work was inspired by anthropology. But I think law has its own needs. Anthropologists are interested in different things and ask different kinds of questions that feed different kinds of answers. And so we need to work on that. And I think that my book is not at all an answer, but rather perhaps highlighting the question more clearly than often is the case. Why write this book? Maybe to go back to the first question that Anne raised, so I partly answered in talking about the protectors of the victims of war. And I might note that the practice that I look at, of course, is one kind of slice of a reality that is on a spectrum. And so there are non-state justice practices and institutions that exist in situations which do not correspond to an armed conflict as understood in international law. The whole gamut of unrecognized states corresponds to that. So places like Somaliland, for example, are places which are not recognized states, but which have a very well-established system for the administration of justice. We might mention Taiwan as another example of an unrecognized state, but which has arguably a much better system for the administration of justice than the recognized state, the People's Republic of China. So what I narrowed the focus of my book for two reasons. The first is just to make it manageable. Already I was somewhat overwhelmed by the variety of rebel justice in situations of armed conflict. And indeed, the variety was one of the drawing points. And I tried my best to have case studies that that reflect very different kinds of armed insurgency, from the FARC in Colombia that were, Marxist-inspired rebels that basically seek to have a different government in Colombia. It's interesting that the FARC wear a shoulder patch that has the flag of Colombia on it, so they're very much not challenging the existence of the state. To the Islamic State, for example, which challenges the very notion of statehood and sovereignty, and is inspired, of course, by a radical fundamentalist Islamic ideology. So the diversity, I think, is enormous, but needs to be embraced because public international law aims at universality. It claims as part of its legitimacy that it applies to all people at all times, everywhere. And so it must therefore be tested against those very different realities. And I note in passing that initially I wanted to have an in-depth case study on South Sudan, the SPLA there. And ultimately, the timing, it was a situation of really great instability in South Sudan. And it was not a good time for me to go. And in the end, I could never. I tried to do the Polisario front. And in the end, the substance wasn't there, which I discovered only after spending a lot of time looking for information. And so, for example, there's no African movement in my case studies, which I feel is a gap in kind of the spectrum of situations that I look at, and I wish I could have done better on that front. So a first reason is just to make it more manageable. A second reason is that international humanitarian law has standard specific rules that speak to the administration of justice in situations of armed conflict that could be interpreted as applying to rebel justice. And it's quite convenient as a lawyer because absolutely everybody's ratified the Geneva Convention. So it's very comforting as an international lawyer to have a treaty. It's binding, it's applicable. And, you know, how does it bind non-state actors? Well, that's a perennial question, but at least for states, it's a starting point. So all the states that I could look at were parties to at least the 1949 Geneva Convention. So I narrowed it for this way. So I wrote this book in acknowledging that I'm writing about one kind of slice of a much broader phenomenon of non-state justice. I think that that led you, Anne, to speak to raise a deeper question, which I often think about, which might be framed as, you know, how humanitarian is humanitarian law, or how much about the individual and the protection of individual interest is international human rights law. And this is something which, if you teach human rights or humanitarian law, as I do, it's one of the main themes of the entire course, is to question and criticize the extent to which this is not the defense of state sovereignty and authority in another guise. And I think to some extent the criticism of these legal standards is well-founded, and that states created standards for the protection of victims of war, but in ways that implied very, very limited self-restraint with respect to practices that were perceived as helpful to win the war, basically. And so this is, I think this questioning is also present in a filigree, you might say, in the book, although I don't think I speak to it directly, but I think it's an important question to ask, and one might ask the question of what does rebel justice tell us about the nature of these international standards in IHL and international human rights law. The Hague Rule of Law Institute on Justice Needs, I didn't know about it. You know, so yeah, there we go, another flaw in my research. There are many, and to be honest, I think I'm not sure I would have seen how to integrate it into the book I did write, but I think you're absolutely right in your intuition that the book suggests a way of asking questions that this database could be extremely rich to use as a resource to ask maybe a different set of questions. But it is kind of bottom-up rule of law thinking, which I think is a flipping on its head the way in which the questions about the rule of law typically have been asked by legal theorists, which, you know, start from the macro and then aren't necessarily too driven by the imperative of making life better for ordinary people. Although, you know, the thin versus thick debate, you know, when you get to the thick part, that incorporates a lot more substantive human rights standards, in particular procedural guarantees. Well, ultimately, these benefit individuals, but they tend to be framed as to what kind of courts do we need, what kind of justice system do we need, rather than what are the needs of ordinary people, and are they met by whatever institution we have created. The structure of the book, yeah, I mean, you could read the book as an anthropologist and, you know, skip all the boring legal parts and just read the kind of the fun descriptive parts. You could be a legal positivist and skip all the description that, you know, whatever, and then read the law stuff because that's what you're interested in. Of course, I wrote the book, you know, mixing them both, and so I suggest to you that it's interesting to read it that way, although, you know, the author doesn't direct how the reader handles the material. There is no doubt in my mind that for example, there is the work is not done on FARC justice or Tamil Tiger justice, right? You would really need, I'm hoping maybe this will encourage some PhD students to write a thesis that is a much more in-depth look at these or other rebel justice regimes, because I really would have needed to spend 5 years in the northeast of Sri Lanka and in the diaspora community to write a satisfying account of Tamil Tiger justice. And I feel satisfied with none of the case studies. I mean, it's okay, but the frustration was intense, and the Tamil Tiger justice system is a particularly acute example because it was such a sophisticated system with 3 layers of courts. The Tamil Tiger had their own law school, and they handled the number that is talked about is more than 30,000 cases, and yet there's nearly no trace of it. The Sri Lankan military was very efficient in destroying all physical evidence of Tamil Tiger justice. Everything was burnt. Many of the individuals were killed at the end of the war, which ended in a great bloodbath. And so many people were killed, and others managed to leave Sri Lanka and do not acknowledge their affiliation with the Tamil Tiger because it is listed as a terrorist entity by most governments. And as you know, if you say you were a member of a terrorist organization, you're not going to have your refugee claim accepted by any country. And so obviously they have to not only have hidden that fact when they came, but certainly in a place like Canada, which is home to the largest Sri Lankan Tamil community in the world, even today, if you disclose that you were a member of the Tamil Tigers, you risk being stripped of your citizenship, because that means you lied in order to get it. And so the block on sharing experience information remains to this day for everybody. And there are still also pro-Tamil Tiger elements within diaspora communities that don't look favorably upon members of that community to speak to people like me, even with all guarantees and have anonymity and all of that. So that's one example that shows how many barriers there are to this kind of research, to say nothing about doing research on active conflict zones like Iraq, which have their own problems. So yes, there is a need for lawyers, for jurists, to look holistically at each of these case studies and other ones. So I agree with you entirely. For me, there's only so many books I could cram in one. It's already a very long book, as the people at Oxford University Press told me when I first sent my manuscript. That was twice the length of the one that I had said that I would give them. And so, and I said to them, well, it's really 2 books in one. And, but so there are limits to how many books you could cram in one. So there's much left to do. Does the book constitute a contribution to legal pluralism? Well, I think this connects to Julia's point as well as to, courts existing not just beyond the state, but against the state, and the extent to which we can make sense as jurists of not merely sort of overlapping legal regimes, but clashing legal regimes that are in opposition in a really fundamental manner. And I think that in that sense, it's a contribution, although I have not sought to theorize that contribution too much in the book, because I had another project that was very demanding on its own. But I think you're right, and the analogy I think we can make is with the legal order created inside the prison systems in places like California, Texas, El Salvador, and this is another example of a legal order that is largely clashing with the legal order of the state, and at the same time, which is remarkably efficient and brings about a degree of stability within these jails that the state legal system itself is completely unable to engineer. And so there's a relationship of dependence or interdependence between even legal systems that are clashing one with the other that we see in the prison system, and which also exists for situations of armed conflicts. So even in situations where rebels create their own court systems, and the legitimacy of which is of course rejected offhandedly by the state relies on that legal systems nevertheless, either indirectly or sometimes even directly. So yeah, the courts of Donetsk, that's a fair question. Although those convictions and sentences of the death penalty handed by the courts of the unrecognized People's Republic of Donetsk against these two British nationals and one Moroccan, and there are more in the pipeline as we speak. There are several problems with that, and I say that knowing not a lot about the courts of Donetsk. I mean, they were created in 2014. These entities adopted their own constitutions. The government of Ukraine ordered its own courts to withdraw from rebel-controlled territory, and progressively the rebels or the Donetsk and Luhansk, the two breakaway republic in eastern Ukraine, replaced them with their own courts, including Supreme Courts in both regions. So to go back to the sentence that you quoted about how to create a court even without law, I mean, in that case, certainly there was a deliberate decision to create courts of general jurisdiction. This is not an ad hoc court. They bring together a few people to judge these guys they just captured and deem them guilty and execute them. So that's another kind of problem. But this is not what we're talking about in Donetsk. So the courts are probably regularly constituted under international law, and so then we turn to, well, how were the cases fairly administered? Was there due process? This is where it becomes a lot more problematic. But information is very scant, very difficult to know what happened in these courtrooms. But what we seem to hear is that there was very limited availability of evidence beforehand, legal counsel for the defense, and so on and so forth. So, that seems to suggest deep problems at a due process level. The extent to which the courts are independent from political leadership. This is I don't know anything about it, but the nature of those rebel regimes raises questions as to how plausible it is that judges would be independent to the degree that is demanded by international law. Finally, in the case of these three individuals, they were members of the regular armed forces of the Ukraine. They were members of the Ukrainian Marines as part of an international armed conflict. And as such, they are prisoners of war. And it is clearly a violation for them to be punished for taking part in hostilities. And at least part of one of the crimes that they have been indicted for under the laws of Donetsk was essentially kind of attempting to overthrow the government of Donetsk. So essentially a different way of talking about taking part in hostilities. So that's a clear violation of international law. You know, whatever that we get into complicated technical aspects of humanitarian law that I don't think we need to get into here. But so I think, but it gives us a good example to go beyond the headlines a little bit as jurists to say, okay, something's wrong with this picture, with these three individuals being convicted to be killed by these courts of the rebels. Something's wrong, but what we hear from the government is that just a kind of a blanket condemnation, which makes sense politically, but which I think as jurists is not sufficient. You know, it's like, in what way? Where is the problem? And then we can actually unpack a little bit and identify particular elements of the problem, which allow us to differentiate between the courts of Donetsk, for example, and the courts of Rojava in the northeast of Syria, administered by the Kurds in that region, where there are also some issues of due process, but much more limited. And so it allows us to place these courts on a map of legality, as we do for states. And I think that we become useful again as lawyers in hopefully nudging armed groups to behave in ways that perhaps will increase their legitimacy if their courts are labeled as fair and lawful under international law. Some rebels don't care, but some will care. So I think that matters. Maybe I just a point in relation to Giulio's note about the place of rebel courts, and just to say that one element that's we must acknowledge, I think, is that it is fine for the courts of an armed group to contribute to the insurgents. And that may seem a little jarring, but for example, you know, the courts of the Taliban are an arm of the Taliban, or were an arm of the Taliban before they became the government of Afghanistan a bit more than a year ago. So that is unproblematic. And in the same way that courts of the states, of course, are an emanation of the state. And so we cannot reproach to state courts that they, you know, represent state sovereignty. And I think likewise, we cannot reproach to the courts of the Taliban that they advance the policies of the Taliban. So this is not what independence and impartiality speaks to. Independence and impartiality speaks more to kind of the structure of the courts and their ability to operate in a manner that is autonomous from interference by other kind of other facets of the insurgency, but without going so far as to demand that they be neutral vis-a-vis the insurgency. Firstly, it's just unrealistic. It's, you know, rebels are not going to create courts like that. And there's no basis in law to demand that rebels do that. Is it possible, you know, could we have outsiders like a UN committee, a tribunal, open a dialogue with rebel courts? I think that this is definitely one of the suggestions that comes out of the book. And what I suggest is that this is happening already in ways that are not really acknowledged. So there are cases right now before the International Criminal Court where some of the crimes that are indictments issued by the courts relate to the operation of rebel courts. And so that necessarily leads the ICC to speak to the specifics of the courts of Ansar Dine, Al-Qaeda in the Maghreb, sitting in Timbuktu in Mali, to give one case as an example. So this is happening in sort of of course, an ad hoc fashion that depends on whatever case are brought to that court. The European Court of Human Rights also has been put in a situation where it had to speak to the operation of rebel courts, including questions like, does the requirement of exhausting local remedies include exhausting rebel courts remedies? And the European Court has answered yes, that in principle there is such a requirement. So there are bits of law that people don't typically put together, but it's quite remarkable what's there already. Other states as well are sometimes confronted with the need to do that. I start the book by talking about Omar Sakan, a Syrian who was prosecuted in Sweden, where he went as a refugee for his execution, his killing of a man caught on video. And his defense was that he was executing judgment of a court of the Free Syrian Army. And this required the Stockholm District Court to basically speak to the lawfulness of the conviction. And in that case, they found it was a violation of due process. Another example, in a more mundane way, perhaps, in courts of Texas have been asked to judge on the lawfulness of the legal regime of the Kurdish region of Iraq that granted property rights in a shipment of oil that the government of Iraq was trying to have seized. And so there are many ways in which other governments are drawn in, typically against their will, because no government wants to be involved in any of this, but it typically occurs through either courts or entities that don't have a choice to refuse to consider an issue. Finally, I've been talking for a while now, but finally, the question about the larger debate about the malleability of the idea of the rule of law and of legal standards, which reflects a long-standing debate in the Council of Europe around the margin of appreciation before in the jurisprudence of the European Court of Human Rights, which are tested by the practices of countries like Poland and Hungary. And I thought you were very diplomatic in not naming countries, and it's my habit to always name countries that I think are doing something wrong. So yes, indeed, and I think that you can take my argument to support a claim for a wide margin of appreciation, and to some extent, because the factors which justify variations must be there. So, state courts are state courts. And so is there really a fundamental reason to differentiate the demands that you could put to a court in Poland as opposed to a court in Germany? To some extent, but to my mind, there's a limited foundation to that claim. Whereas when you look at other kinds of entities, a religious tribunal, what is fair, what is due process before a religious court, even a religious court sitting in Poland or Germany, I think, well, that's a different question. And there, you have to, due process must reflect the nature of the judicial process as a whole, and of the kind of practice and institution that it is connected to. And so it is related, but it's certainly not an argument for sort of a free-for-all that, you know, well, okay, that means that whoever can do whatever they please. Quite far from it, as far as I'm concerned. So let me stop here.
Great, thank you, Renee. So we have about 15 minutes left. Let me open the floor. If members of the audience want to ask a question, you're welcome to send questions through the chat or to click the reactions button and raise your virtual hand. So while they do that, perhaps I can ask a question. Well, actually, let me go to the audience. Brad Roth, please go ahead.
Yes, good to see you all. I was wondering in regard to the question of how one deals with judgments of courts in rebel territory after the fact, or perhaps after the territory has been recaptured and so forth. Whether the old doctrine of implied mandate mightn't have some significance here. The idea that essentially there are circumstances where illegitimate governments perform legitimate tasks, that the illegitimate government, insofar as it is performing only the kinds of tasks associated with the keeping of order in the territory, is really doing what the sovereign would wish to have done in the territory in any event, and that those official acts by the rebel group would be sort of adopted after the fact. Whereas anything distinctively pursuing the illegitimate objectives of the rebel group would be treated differently, and indeed people could be prosecuted for treason or whatever kind of offense associated with fulfilling the distinctive purposes of the rebel group.
Great, thank you.
So I think that's a great question. It's really important and really neglected, because the general approach is for governments to simply have a blanket denial of legality, legitimacy to what the rebels do, and within what the rebels do, claims to seize the mantle of justice by rebels is the most rejected by the government, right? Because the government's view that as an attempt to legitimize rebel authority. So the approach in all cases that I've looked at is for governments to simply deny that there's anything there, and to simply seek to erase at the end of the conflict all traces of rebel justice. Situations where the rebels actually become the government are different, like the Taliban. So one presumes that they will, of course, recognize their own administration of justice. So implied mandate, I mean, this is a part of the International Law Commission's articles on state responsibility speak to that. I have to call Article 8, I think. I don't have, I'm not sure whether it's 8 or 9 offhand, but it speaks to somebody exercising state function in situation where the state is unable to do so. And questions have been raised as to whether rebel justice can be one such situations. And there are, the answer in international law is unclear, that states would be willing to concede that if rebels expel them militarily from a territory, that there could be an implied mandate by the government for the rebels to take over the administration of justice. The claim is hard to sustain because the notion of implied mandate speaks to some form of consent to delegate by the state, and very clearly states do not intend to delegate anything. So there's a challenge there. Brad speaks in ways that are very that remind me of kind of a strand of jurisprudence from the United States Supreme Court after the end of the Civil War, which had to consider what to do with the decisions of Confederate courts during the Civil War in the United States. And during that, during the period of the Confederacy, federal courts essentially were replaced by Confederate courts, not rarely sitting in the same courtrooms and quite often with the same judges that had been federal judges and became judges of the Confederate government, often applying the same law because the Confederacy didn't legislate that much. They were busy doing other things. So the issue after the end of the Civil War became, what to make of this. And initially, the Supreme Court was quite absolute in its rejection, that none of this was legal and it was all just a facade of justice. But quickly, it became clear that the approach had to be a little bit more discerning. And the distinction that was made is the one that Brad briefly echoed in his question, which is to differentiate between court decisions that are really sort of an act of insurgency and that seek to advance the cause of the insurgency. And so, for example, punishing traitors. So somebody who was a traitor who provided information to the Union and then was caught by the Confederates and so was prosecuted for treason before Confederate courts and sentenced to whatever, 10 years in jail. Does that sentence still stand at the end of the war? Well, clearly the answer is no. And so that is one thing. A contract for the purchase of bales of cotton about which there was a dispute, which is kind of unrelated to the conflict. Well, if compensation was ordered, is there a reason for that judgment not to be executable after the end of the war? And the court finally concluded that really this didn't have much to do with the insurgency, and therefore the judgment should stand. Then there were purchases of cotton to make uniforms. There's a big gray zone, so it was not necessarily easy, but at least the principle became a little bit more sophisticated. 150 years later, that jurisprudence from the United States Supreme Court remains the most sophisticated judicial analysis or grappling with rebel justice that we have. And it's an area few American constitutional lawyers know this area. So it's a relatively obscure part of American law because there's no reason really for people to know about it. But I think for international lawyers, it suggests a path that is promising. But if you go to Colombia and you speak to people in the judicial system or in the justice and the government about decisions of FARC justice processes, they didn't really set up formal courts. You just met with a blank stare, and if they know something about it, it's just no. And people have been prosecuted for commanders for sanctioning a process that led to the conviction, for example, of a child molester. And the attitude of the Colombian Supreme Court is this is an act of terror, as is basically terrorism. And the commander was convicted for a very long period in jail, despite the fact that it was not obviously an unfair trial. looking into the details of how this child molester was prosecuted, it's the basic elements of due process were respected for this kind of a popular assembly decision that was held. And so to me, that is a deeply problematic stance. Going back to Sri Lanka for another example, in Colombo, I asked lawyers, judges, what about all these decisions, thousands of decisions issued by Tamil Tiger courts during the war about property ownership or whatever, like ordinary things, and they just thought it was absurd to suggest that somebody could bring up a judgment of the LTTE court. But then when you go to Jaffna and you go to the court of Sri Lanka sitting in Jaffna, that's exactly what is happening. And I have one judgment where the plaintiff adduces his judgment issued by the courts of the LTTE about a property dispute, which is accepted by the judge. But this all is done in Tamil, and the people in Colombo, typically they don't speak or read Tamil. So there's a different reality when you go further from the capital city. That's true in every conflict zone. And so it's happening because it has to, because it would be obviously unfair to refuse to accept it. And also you cannot undo years of the administration of justice. The same applies to belligerent occupation, where you cannot, after the end of World War II, mostly the judgments of the occupation courts in France stood, including really radically unfair, unjust, racist, anti-Semitic ones. Mostly they were left untouched because you cannot unwind the clock of one legal act leading to another, to another, to another, and it's impossible. So you must live with it. But lawyers have not really thought about or offered ways for governments to figure this out. And so we're left with really kind of bland and unsatisfying statements of blanket illegality and terrorism and all of that. But I think that, for example, the Hague in Colombia, the special jurisdiction for peace, I think should speak to this dimension of the war in Colombia to try to devise an approach that might be something like the U.S. Supreme Court did after the end of the Civil War in the United States. So, but it's a very important question that is, I think, to this day, nobody talks about this.
Okay, and with that, I think we should wrap up. We're just about out of time. Sincere thanks again to René. Thank you very much. Thank you so much to Anne and to Julio for these comments and the questions you posed. It's really fascinating discussion. Really excellent. Thank you so much. I'll just end with a quick plug for our committee, which is keep your eyes open for social media and email announcements. We try to do one of these book talks a month. We just had a kind of a break for the summer, but we hope to have them starting regularly again after this. So I hope you will join us for future installments of this new scholarship showcase. So thanks again, everyone. Good night.
Thanks so much once again, and thanks, René. Thank you. Bye-bye.
Thank you all.
Bye.
Thanks.
Bye-bye.